many users who would cause no harm at all. There is a percentage, and you would say, well, you can't prohibit it because you have to target the percentage that abuse it. And how do you know how to identify those people and get into reviewing many pieces of legislation on that sort of basis?
Well, again, we go back to two things. First of all, the nature of the harm caused. Even if the harm, and we tend to use that word loosely with respect to the possession or more appropriately use of marijuana, does materialize, it's not of the same order as the potential harm associated with handguns. That is, the harm that we're concerned about with the possession of handguns is someone getting shot. That's obviously very significant and serious harm by definition. There's not been any report, Royal Commission, Commons Committee, Senate, wealth of opinion to suggest that handguns should be decriminalized because they're safe. It's one thing to say they should be decriminalized because we have a right to not have the state interfere with our liberty, but it's another thing to say that there's no need for any kind of firearms registry because there's no harm associated with the activity. The three examples that the Crown gives as saying that somehow the harm principle would give rise to challenges to the over 80 offense or to food manufacturers who are adulterating the food or to corporate polluters, in my submission, again, help illustrate why the harm principle is not unmanageable and why this case is unique. Unlike those prohibitions, the putative need for a criminal sanction with respect to possession of marijuana has been repeatedly and consistently condemned by government reports here and abroad. If you look, though, at some of the examples that the Crown provides, for instance, the Hydro-Quebec case, in that case, this court pointed out that the law was supported by those kind of international bodies and government commissions. So in other words, somehow saying there was no harm went against the wisdom of those reports and of those who had studied the law. None of the respondents' hypothetical challenges to somehow suggest that the harm principle would open the floodgates, none of those situations have ever found, nor would they ever find, support from any kind of government committee or commission. And the significance of the fact that this particular criminal prohibition has been repeatedly condemned by commissions, government reports, all those who have studied it, it can't be gainsaid. This court in Phillips, as is noted in paragraph 36 of the Clay factum, emphasized the importance of royal commissions of inquiry to the legislative process. That is, it made clear that inquiries, while an extension of Parliament, are actually better able than Parliament to take a long-term view of a social problem because of their fact-finding capacities, because of their lack of any kind of partisan bias, etc. So the fact that you have not only the Ledane Commission, but also parliamentary committees themselves, both the Senate and the Commons Committee, supporting the fact that the response of a criminal prohibition is disproportionate, in my submission, is what gets us over whatever standard you want to set for the harm principle.
I guess what I'm having a concern about is that you seem to be saying all of these attacks by commissions and critics basically come out to a cost-benefit analysis of a prohibition on possession of marijuana with imprisonment. It's a cost-benefit. But even if it is on a cost-benefit basis, shown to be that this is not an enlightened law, it's not the optimal choice, why does that make it unconstitutional?
I guess simply put, because the Charter says that there has to be some limits on Parliament's authority to determine what is a criminal offence, not in terms of a limit as to what they can prohibit, but something that they can actually criminalize. Otherwise, there's nothing stopping Parliament tomorrow from criminalizing not wearing seatbelts or golf because they have some evidence that many people get struck by lightning on the golf course. I take your point about it being a cost-benefit analysis, but where's the evidence that the government has to respond to all of what has been said year after year, decade after decade by the Royal Commissions?
First of all, you're the claimant. You've got to show that Section 7 has been violated. So I think Justice Braidwood, quite correctly pointed out where the onus is on Section 7. It's in the claimant, and we said as much, I think, in the Mills case. Mm-hmm. So first of all, it's with you on this one, and I thought the answer is in the findings of the courts below. They have found that there is a harm principle, that there is a reasonable basis here for non-insignificant, non-trivial harm to take place.
Let me deal quickly with the test that, Justice, that you identify from Justice Braidwood's decision, the not insignificant or trivial, because that, in my submission, also helps demonstrate why the courts below have erred in their assessment of this. Justice Braidwood's formulation of the test, in my submission, breaks down the moment that he suddenly graphs on to, he goes through his reasons, I'm not going to take the court through them, all the examples in the jurisprudence that say that there should be a harm principle, that, cases have suggested that there has to be some measure of harm, whether it's serious, substantial, and you get to paragraph 138 of his judgment, and I'll just give you the reference, it's in the Malmo-Levine Appellant's Record, Volume 2, the Court of Appeal judgment it starts at 241, and at page 319, and you'll see, if you follow through his reasoning from 104, paragraph 104, which is where the harm principle starts, he goes through all the examples at common law, leading treatises, law reform commissions, federalism cases, charter cases, and nowhere in any of those cases does he find the language that he then attaches in the last sentence of paragraph 138, where he says the degree of harm must be neither insignificant nor trivial. Usually, all the other cases styled it as serious or substantial. In my submission, he arrives at that not trivial threshold by taking a line from this court's decision in Cunningham out of context. And you see that in the next paragraph, on the next page, at paragraph 139 at 320. The line he takes from Cunningham in that quote, the Charter does not protect against insignificant or trivial limitations of rights. But that trivial threshold was a threshold which this court in Cunningham imposed on rights claimants to get over the first stage of the Section 7 analysis. That is, this court created the not trivial threshold to screen out rights claims based on remote or minor effects of the impugned law. Justice Braidwood turns it on its head. On his formulation of the harm principle, trivial becomes the threshold that the law has to get over, not that the rights claimant has to get over. In other words, on his analysis, it has nothing to do with how much or how little the law impacts on the rights claimant, which is what the formulation in Cunningham was speaking to. Justice Prowse recognizes this flaw in Justice Braidwood's decision in her dissent at paragraph 175, which is, don't have the exact page, it's about page 341 or 42, but she settles on the formulation that is readily apparent from all the cases, reports, and writings on the issue that Justice Braidwood had earlier referred to. And if you accept Justice Prowse has correctly stated the threshold for harm, it's clear, as I submitted before, that Justice Braidwood would have, like her, also have found the criminal prohibition violated Section 7. So there you would have had 3 judges satisfied on the basis of the extensive evidentiary record that there was not a significant or serious amount of harm associated with the criminal prohibition on marijuana.
Can I ask you this, because I'm still not clear on it? It seems to me that these justices, both Justice Prowse and Justice Braidwood, come up with the conclusion that there is indeed support for a harm principle. Good. But where they differ is on what that harm principle means. Justice Braidwood says there has to be significant or non-trivial harm, which is almost close, in my mind anyway, perhaps I'm wrong, and if I am, you'll tell me, to that arbitrariness threshold that you say is distinct from the harm position. But it's getting close. It may be the same thing, because if you have a trivial harm, you could argue arbitrariness. So Justice Braidwood says there is a harm principle, but that's what we do under that principle is simply look for whether or not there's some non-trivial or whatever harm. Justice Prowse takes it further. She seems to suggest that there's a proportionality aspect, a weighing, a balancing. You've got to show that impacts are greater, etc. So in that sense, they seem to be saying the same thing to a certain point, but then a very different thing. And what I'm not hearing from you so far, unless I've missed it, is why one version of the harm principle is better than another version. I mean, to me, it comes down to that, at least in part.
Well, Justice Braidwood and Justice Prowse rely on essentially the same sources to get to the harm principle. They both rely on the leading treatises, the We Met report, the Law Reform Commission. Even though Justice Braidwood endorses those as his source for the harm principle, as I say, it's when he gets to the last step and he sticks on the not insignificant part.
You're missing my point. I'm saying I understand you see it that way, but try and see it my way, because then you can help me with my difficulty. And you can tell me if I'm wrong to see it this way. It seems to me that just saying harm principle begs the question of how one goes about evaluating what threshold that harm has to meet. That's my concern.
In order to use the criminal sanction, what Justice Prowse is saying is that if you look at the history of our common law, as well as the other sources that both she and Justice Braidwood referred to, that it is a principle of fundamental justice that Parliament is not entitled to criminally proscribe any activity. And in terms of what activities Parliament is entitled to prescribe, she develops, as does Justice Braidwood, presumably until he gets to the end, the fact that the test for harm has to be serious or something more than not insignificant.